Hello, everybody. This is Greg Paielli. I have a co-host here, Jose Montez. He's an account manager with our company here at Simply Property Management in Las Vegas. And I also have Christopher Walker from the law office of Scott Clark. And I wanted to welcome both of you and thank you both very much for attending today. There's a lot of things I think we all know about that's been going on with the property management business in both states. And we're here to talk a little bit with Chris. And so, Chris, can you tell us a little bit about yourself and where you're from and your education and how long you've been in the business? You're the lead attorney, I understand, at the law office of Scott Clark. And give us a little information about yourself.
Sure. And thank you for having me, Greg. So I'm the managing attorney of the law office of Scott Clark. I oversee our operations in Arizona and Nevada. Those are the only two states in which we're doing business. I was born in Santa Monica, California. We moved out to Tucson, Arizona when I was about 6, moved up to Phoenix in my junior year of high school. I went to ASU. I got an undergrad in psychology, and then I went to law school in Kansas. And after I left Kansas, I came back to Arizona, took the bar, and I've been with the firm for 8 years. 8 years actually next month. And in that time period, there's been a lot of growth in the firm, a lot of change in the property management industry in terms of the laws and regulations that we have to deal with, and as well as the political climate. So it's been an exciting adventure. Sky's the limit. I'm excited to be the managing attorney here at the firm, and I think there's great things in store for the firm as we go forward.
Oh, that's great. That's great. And do you have you represent? Do you represent like multifamily, and you represent single family owners, or what's your reach of the law that you guys practice there on a regular basis? I know that there's multifamily, there's commercial, there's manufactured housing, there's mobile homes. What do you guys do over there exactly? Could you tell us a little bit, Chris?
Yeah, absolutely. So we represent managers and owners of single-family, multifamily. We do some work for manufactured housing. We do some work for the mobile home parks. We also do some commercial evictions. In Arizona, commercial evictions generally are guided by self-help because that's authorized by the statute. So I don't typically get involved in those too terribly often unless the lease agreement requires us to give formal notice and go through an eviction process. But to answer your question succinctly, yeah, we represent pretty much everyone in any landlord-tenant transaction in the state of Arizona. I
see. And so, today on these, I know that things aren't the same right now, but on a normal eviction here, we'll start out maybe with Arizona first. What's the general process that you guys go through, or what is the general process for let's just say we'll start out with maybe non-payment, and we realize there are some other forms as well.
Yeah, I mean, eviction types can really be broken down into 3 main categories in Arizona. One's going to be non-payment, the other one's going to be non-compliance, and there's various non-compliances, and the third will be non-renewals. So with regards to non-payment, your first step is identifying the breach, and usually it's the tenant hasn't paid all or some of the rent that's due and owing. Assuming the tenant hasn't made any partial payment and there's no partial payment agreement in place, you would issue a non-payment of rent notice, which in the state of Arizona is a 5-day pay or quit. Now that's 5 calendar days. You have to serve that notice as set forth in statute. Statute authorizes 2 means of service. One is personal delivery, which puts the notice in the hands of the tenant. And the other one is certified mail, or it's not often done as one by registered mail, so mailing. That process requires adding an additional 5 days onto the notice period. It's deemed received by the tenant 5 days from the date of mailing. So once you get your notice in place, you've served it, and it expires, that's when you contact your attorney. That's when our firm gets involved. And what we do is we have to, under new rules from the Supreme Court this year, we have to attach a copy of the lease, the ledger, the notice, and any relevant other portions of the lease agreement, or any relevant exhibits if there's additional monies owed other than just non-payment of rent funds in the lease, to our complaint. In Arizona, we're able to file these actions, and they're called special detainer actions, and they're for relief that's sought under ARS 331368. And what that allows us to do is to have a different means of service for special detainer actions. We're able to either personally serve, which is a traditional way of serving a lawsuit. You have a process server put in the hands of the defendant, the complaint, and the summons to the court. Or under special detainer actions, we're allowed to do what we call post and mail. And that's we post a copy of the complaint, the lease, the ledger, the exhibits, the notice, to the door or in a conspicuous place, and then we mail it, certified mail, to that address. And then within 5 days of us having filed the action, we have a hearing date, and we get that hearing date on the complaint and summons. So you know when we file what your hearing date and time is, and we come to court. And when we get to court, then it becomes an issue of whether or not the tenant appears. And if they appear, the court is tasked with determining that the landlord-tenant relationship exists, proper notice was given, the tenant did not comply, the tenant is in breach of the lease agreement, and the landlord is entitled to the relief requested. That was the world that we lived in pre-COVID. Once you got a judgment, you have a bit of restitution issued within 5 days for a non-payment rent case. At that point in time, you could file for that bit of restitution, and the court would execute that shortly thereafter, and you could expect, even in the busy period of time, a constable to arrive between 24 to 48 hours after that writ of restitution was granted.
That's really good. And so the whole process takes maybe back before the pre-COVID, about 30 days, I would say, or so, 40 maybe, or what's your estimate on it?
Depending on the method of service for the 5-day notice, you're looking at anywhere between 23 to 28 days.
I see.
Process to go through.
I see. And do you think that the courts, I know you mentioned that the Supreme Court now wants you to attach a ledger and a lease and all these things. You think they're trying to get away from some of the hearing things if they see the ledger and the lease? I mean, what's the purpose for all this stuff coming into the court now, do you think? Well, what's the purpose behind it?
I think the purpose was to give the tenant more information to help them prepare for any defense that they may or may not have. And so, from a procedural standpoint, we opposed the rule change because we thought there were some flaws in the rule change. The rule change was pushed by the State Bar of Arizona. We commented, I wrote the comment for the firm in the Arizona Multi-Housing Association, to which we're counsel. And we pointed out that we thought this might divulge confidential information because some people put DOBs or socials on a lease agreement. And that we were concerned about some of these things being posted on the door.
Exactly.
But what ultimately it was decided to let it go through, and that's fine. We did it. Unfortunately, it increased the costs because we had to get more equipment, more personnel to put these files together. Our processor charges more for it, so there was an unfortunate consequence to the tenant. But ultimately, at the end of the day, I think it's proven to be somewhat more effective. Because the tenants don't only go, I don't understand what's in the complaint. They have a ledger they can look at and see. It shows them what exactly we're asking for on the basis. And I think that's cleared up some confusion. And so I look at the law ultimately as it's been beneficial.
Yeah. I mean, definitely there can be, unless they're going to contest payments. Really, I mean, it's pretty much there. Then if they do come to court and they're going to contest it, then they probably need to come, I would imagine, with their copy of their canceled checks or their canceled money orders to prove that the ledger is wrong. That's probably one of their defenses, I would think, huh?
Yes, I paid my rent or I made a partial payment would be what we call an affirmative defense in the state of Arizona. The tenant has the burden of proving that. They're not required to come to the initial hearing with that evidence necessarily, but they would certainly have to present that at trial. And so with these hearings, when we get the initial hearing, that's what it really is. It's basically a plea ceremony. The tenant pleads guilty or not guilty. And if they plead not guilty, they have to assert a legal defense. And if we have a legal defense, then we're going to set a trial. And by statute, pre-COVID, that trial had to occur within 3 days of that initial hearing.
Yeah. And I've seen it happen the same day. I've been there before, and it happens like, I'll take you at 3:30 or something. So
well, there is a preference. If it's an immediate eviction, the preference is to get that done as soon as possible.
I understand that. Yeah, that's correct. That is correct. Okay. Well, that's very interesting. And then just one other thing on the partial payments. Those you can't take a partial payment in Arizona, can you? It has to be in writing, does it not?
Well, yes. So the statute is ARS 33-1371, and it requires that if a landlord's accepting anything less than payments in full, that contemporaneously with the acceptance of the partial payment, they need to execute a payment agreement that says that the landlord's not waiving their right to proceed forward in eviction under the statute, and that the tenant has to pay the remaining balance on some date certain. Mm-hmm. And so we call that a payment agreement, a partial payment agreement. So yeah, it's very important that you have that, because if you don't have that and you accept a partial payment, even if it's $5 and it's clear no landlord was waiving their right to the remaining $995 of the $1,000 monthly rent, without that promise to pay agreement in place, the court will deem you have waived your right, and they will not allow you to file an eviction that month. Now, the following month, you could issue a notice, and you could then begin the court process the month after. But that's a significant delay. Owners don't typically like that. So it's recommended that if you're going to accept a partial payment, that you do the payment agreement. But by law, landlords have no obligation, even during COVID, to accept a partial payment.
Right. Now in Nevada, it's a little bit different, and they've had some changes in the law in Nevada this past year, is to my understanding. The notice, the notice, some of the notice dates have changed. You feel like commenting on that a little bit, on the process of that?
Nevada is a different animal. So Nevada's eviction process it's a summary proceeding as well. They use judicial days. And their non-payment of rent notice is a 7-day notice. Again, this is all pre-COVID, right? Uh-huh. And so it's 7 judicial days. A recent change in Nevada is they decided to go to a 4-day work week, so which means we've lost a judicial day during the week. So we're no longer counting Fridays. We can't. So we have to go Monday through Thursday, and then we have to count them the next week. So it ends up causing a delay, which I'm not going to comment on whether or not they should have done that or not. I think that they may need to go back to calendar days instead of judicial days, but that's up for the legislature to make that decision. This just gives the tenant more time to move out or pay, in my mind, which I think was maybe an added bonus to it. But the notice process is the same. We had a change in the law last year, though. Prior to July of last year, landlords could serve their own notices. You didn't have to involve a lawyer, and it's a process server, and it's called a constable or sheriff. Well, in July of last year, that law changed. So the landlord can no longer serve its own notices. They have to serve it through their lawyer, the constable, process server, or a sheriff. And so that has greatly changed the process. There's an attestation on that document about how it was served. You have to attach the certificate of mailing, because we're allowed to post and mail via registered mail the notice of non-compliance, the 7-day non-payment of rent notice. And those documents typically have to be filed with the court. There's a standard complaint. You attach the notice signed by the person that served it, and attach the certificate of mailing to it, along with the full copy of the lease. And if you're in the Las Vegas Justice Court, a copy of the cover sheet for the eviction. And that's how we start the process. All those cases in Vegas, they're filed online. And unless a tenant files an answer, and they've got a 7 judicial day window to file their answer. If they don't file their answer in that 7 judicial day window, and we file our complaint for summary eviction, we get judgment. And the judgment is just possession. There's no monetary award in a summary eviction now. Landlords can opt to do a formal eviction, but that takes the route of more of a traditional lawsuit. You've got a formal service requirement. You have a 30-day setting before you have a hearing date. You have a trial, and then if you win on the merits of trial, you get back possession and an award of the monetary sums owed under the terms of contract that were breached by the tenant.
I see. Well, that's definitely, they've had some changes here. I've noticed in our operations slowing down the process, to get people out, of not paying rent. So, like you said, some of this is the political winds, that come through. And we have to deal with that as landlords and attorneys as well. We all have to make some changes. So now we're coming out of, so we are no longer in that particular part of our life, at least at this time. We're into, this COVID thing now, and things have really changed. And there's some differences between the two states, but not a lot. But Arizona seems to have a little bit more things, a little more flexibility since we had this COVID thing, is from what I've noticed. So, can you take us through a little briefly on Governor Ducey? Governor Ducey is from Arizona, and I just wanted to explain to my listeners that he's the governor that gave some orders, and there's some other things going on with that. Could you just briefly kind of cover his order and any orders after that that he gave, Chris?
Absolutely. So the first order to reference is going to be Executive Order 2020-14. Now, that one came out in March. I think it was March 22nd or 23rd. It was the week the CARES came out. And that order said that due to the pandemic, that the governor was directing the constables, and the constables are part of the executive branch, that the constables were to delay the execution of the writ of restitution, otherwise the lockout of the tenant from the premises, in furtherance of the eviction order, if the tenant met one of 5 conditions. Now, one of those conditions was the tenant had COVID. The condition is someone in the house had COVID. The third condition was that the tenant's just been advised to quarantine himself because they may have COVID-like symptoms. The fourth one was the tenant has some underlying medical complication that makes them more susceptible to greater harm if they were to contract COVID. So another reason potentially to quarantine yourself and avoid exposure. And the fifth and most common issue that we saw was someone that suffered a substantial financial loss due to COVID-19. And so to prove that, tenant had to show that they lost their job, reduction in income, lost hours, or that they had to stay home to take care of a school-aged child that was homebound. Because when this order came out, we were still in school. So we still had some time left. And so if you were able to satisfy those things, then you've got a stay of your writ of restitution. And that stay went through July 23rd. And so, we had a lot of motion practice on that because it did authorize the landlord to file a motion to compel. So you say, hey, the constable got it wrong. This case needs to be followed through with a lockout, and here's why. And some of those cases were successful, some of those cases were not. And that ended up being the precipice for the filing of special action. But before the expiration of Executive Order 2020-14, Governor Ducey decided he was going to extend that. And he did that through Executive Order 2020-49. And that order is somewhat of a hybrid. And it's a hybrid in this case. From the date it was enacted, and it was enacted mid-July, I think like July 18th or so, I can't quote me on the date, but he said from the date of enactment through August 21, the rules I just gave you with those 5 grounds for relief are applicable. And the tenant can seek to delay the execution of a writ for any one of those 5 grounds. It changes on August 22nd. On August 22nd, it goes less from I've got COVID or I've been ordered to quarantine. It turns into a financial issue. So starting August 22nd, there's 3 criteria that need to be all met by the tenant in order to stay. And those criteria are the tenant can prove an ongoing and substantial economic harm due to COVID-19. Number 2, the tenant must request in writing that they get a payment plan from their landlord. And then third and finally, tenant must provide a copy of a completed application for rental assistance with state, county, or local municipal rental assistance agency. Now, the tenant can meet all 3 of these, and it is a non-payment of rent case, or in some judges have claimed a non-renewal matter. Then the tenant can delay the execution of the writ of restitution through October 31st. Now, the order says, and as it did back in March, that if in the interest of justice, the execution of the writ should occur, or if the case arises under ARS 33-1368A, which is our non-compliance statute, then the writ of restitution should issue. So those avenues still remain in place, although I will say for your viewers, your listeners, the interest of justice is not really a successful argument. We've seen no success there. I've not. I've argued it, and I've just been unsuccessful in pleading with the court to understand that financial harm to the landlord, potential loss of the property through foreclosure, is something the court should consider as in the interest of justice. especially for some of the smaller property owners. They own one house and their retirement funds are in that house as its sole retirement investment. And so it's been a very interesting situation. And again, part of the reason behind the filing of the special action you mentioned at the beginning.
Yeah. It just seems like there's just, and we'll talk a little bit more about this a little later on, but it just seems like there's just so many things hoops you have to jump through. It just seems like we're taking rights of one party and we're putting them over the property rights. And I've been having a hard time understanding that since March 15th. And I think I've had conversations with you and several of the attorneys at your office there. I know I had a fiery comment with Colin there one early on, like March 16th or whatever. So, about constitutional rights as well. And so Governor Sisolak now, he's got orders, but they're just much more clear. There's just no evictions, right? Is that what's going on? And you can't even talk to the tenant, I understand, anymore. We do have some people in Nevada, they haven't paid rent since March, and there's no even putting a notice on the door for them,
Yeah, Governor Sisolak's order was by far more restrictive. And while it was clear, at least, in each of the orders, there's been several directives. He calls them directives. And I haven't committed them to memory because there's been too many.
Oh, yeah, there's too many. Yeah.
But
exactly.
Basically, he said no more court access. And he shut it down for every eviction type, nearly, except for those that involves like substantial risk of harm or substantial health and safety cases, which, the problem I have with that is it's such a subjective standard.
Right.
And so, you have one judge that agrees with you and another, we have 3 different judges out there. You've got North Las Vegas and they have various judges that hear the cases there. You've got Henderson, you have various judges that hear them there. You've got Las Vegas Township and they've got one hearing master that hears them there. So you have a little bit more consistency out of Las Vegas Township, not as much out of North Las Vegas and Henderson. So when you have a subjective standard, just because I'm arguing, it doesn't mean the judge can agree with it.
Right.
I come from the standpoint of protecting the rights of the property owner, understanding that there might be some things that give rise to premises liability. I'm looking to skirt away from a lawsuit down the road. I'm looking to protect the remaining 500 people that live at the apartment complex. I'm not really worried about this one tenant that we're going to be evicting in the midst of COVID. The needs of the greater majority outweigh the need of that one person. I want to try to protect the community, as is my client's obligation. So, the governor's order has been simply, no non-payment rent case. You couldn't even issue a non-payment rent notice. And if you did, you got a nasty gram from the attorney general out there. They came down pretty clear that they were going to go after people. And I'm unfortunately watched them try it with several of my clients now successfully. We've gotten all those taken care of and off the books, and nothing resulted in any actionable violation. But again, it was entirely subjective. I look at something and say that's innocuous. I think that the client, was just communicating, hey, you have a balance need, please communicate to us. Depending on which AG got it, again, subjective standard, they would come back and say, no, this is too harsh. Tenant feels they're being harassed. And we could talk about that ad nauseum. But at the end of the day, I think the property owner had the right to provide a balance due letter, and we created one. And ultimately, I think we got the AG's office to back off a little bit, acknowledge property owner has the right to say, hey, come on, just talk to us, please. If you need to work this out on a payment plan, let's do it. If you need to work out some kind of agreement for cash for keys, let's do it. If you need some time to move out, please, let's do it. And so I think that's really important to allow the parties to communicate. I think at the beginning of this, it was unfortunate because some of the directives from the AG's office making that sound like he couldn't communicate at all, which I obviously disagree with.
Yeah, I didn't understand that myself. If somebody's in the house, we can't even call them. What happens if they're not in the house? What happens if, so we took the approach, we called them and asked them how they were doing. Are you safe? Do you have COVID? Are you okay? Just not to get rent for and not be able to talk to somebody and communicate to them. It just seems absurd, But I know that's the things that they're doing. They try to scare everybody, to do it. The thing that started all this, in my opinion, is Trump's order initially. I believe that had a lot to do with all these governors just doing this when he said no eviction with for these Fannie Mae and Freddie Mac loan homes, or that have loans with Freddie or Fannie. And so I found that kind of started the ball rolling. I think that was the first one. Was that the first order, Chris, that started the CARES Act? Or
well, Ducey beat Trump to the punch. Ducey's order came out the week of Trump's.
I see.
I think in the last 4 or 5 months have been somewhat of a blur.
Yeah.
What's interesting is the week before I was in DC at NAA, and we were lobbying these same congressmen and senators that signed this bill. And so we were, having these conversations about, not having rent control and talking about the interest of property owners and, how we want to work with people but we want to protect our investments. And so we come back and COVID was going on. And while we were there, in fact, I recall the Thursday before I left, the Capitol shut down. No visitors. And so COVID became very real. And, we had to hop on a plane with a bunch of other people, 300 other people, and fly back to Phoenix, worrying about COVID. And we land here in Phoenix, and I've lamented several times, it's like we went through some kind of wormhole. I came out in a different universe. And it has been a sprint ever since I got back. It's been an incredible time to be an attorney in this industry. I don't think we've ever been pushed as hard as we've been in these last 5 months to immediately change direction on how we've done things under existing law for decades, to render advice on a pandemic that hasn't occurred in our lifetimes. The 1918 pandemic is the only one that's close to this one. And there's not a single lawyer in my firm that was alive back then. So for us to basically reinvent this wheel and discuss, sanitation procedures, how we open pools, and how we open gyms, how we communicate, how we handle work order requests, when we can and can't send in our guys to do work order requests. Are there work order requests we should delay? And that was mainly the conversation back when the stay-at-home order was in place, and advising clients if they were essential workers. In our industry, they were. This firm never shut down, not one day. I've been here every day. My guys have been here every day, working tirelessly for this industry to provide the support it needs and was required to get through this. But to answer your question, no, Ducey did jump the gun on it. Trump did sign the CARES Act, and the CARES Act was a surprise. There's no mixing words about that.
Yeah.
There was Section 4023 of that act was the optional forbearance of the mortgages, with the requirement that if you do the forbearance, you do a moratorium. But then it went from the House to the Senate, and then it went back, and the House added in Section 4024, which is the mandatory moratorium, and Trump signed it about 3:30, about 1:30 Arizona time on Friday, March 27th. It's going to be a day that's going to live in my mind for the rest of my life. And ever since then, it's just been a scramble on how to figure out how to interpret this. I'm counsel to the National Apartment Association. We've had a lot of conversations about how do we interpret that section. We've had a lot of differing attorneys on the tenant advocate side argue about the moratoriums for every eviction type, which clearly is not supported by the black and white lettering of Section B of 4024. And then now what we're dealing with is this 30-day notice to vacate. What does it mean? What does it apply? What's the duration? So, the CARES Act really did throw a huge wrinkle. And I think a lot of governors, once they saw that, they did follow suit and put in some level of moratorium, which has been what I've been arguing on a national level is why the CARES Act should go on. And there was a point in time, every single state in our union had an eviction moratorium. We didn't need a federal law on it. Every state was doing it. And let's be clear, as a lawyer, the Constitution is sacred to me. I know what it says. I know the powers enumerated in it. And I look at this and I go, this seems awfully much like a police power issue. And our Constitution delegates that to the states. And so I think the states are all uniquely situated to actually decide, should there be an eviction moratorium. California is far different from Arizona. Will never be the same. Arizona is far different from Wisconsin or Wyoming. No two states are the same. And so no two states share the same need. And no two states have the same level of contagion of COVID-19. And so that's why I've always advocated states should make these decisions. And I think we're starting to see some of these states realize, hey, we're coming through this. Arizona's positivity rate's going down. Maricopa County's rate's still a little higher than we wanted. But overall, Arizona is on the decline, both in hospitalizations and deaths. And so we're looking at this and from a forward trajectory of seeing light at the end of the tunnel. And I think, and I hope that's somewhat of the rationale behind letting the moratorium under the CARES Act expire and not signing on to the HEROES Act.
Right. So so at the end of this CARES Act, there was a controversy because we have a 5-day notice, here in this state here in Arizona, and I know Nevada's got a 7. But the question is some for non-payment of rent, they would have had to give a 30-day notice. Is that how I understand it? And that's like a 5-day notice because of the CARES, because of jumbled up language in the CARES Act. Is that right? Did I understand that right, Chris?
You did, Greg, and that's going to apply for Arizona and Nevada. In Arizona, if you're evicting someone for non-payment of rent after the expiration of CARES, and you have a covered property, and that's someone has a Fannie Mae loan, Freddie Mac loan, you have a loan through HUD, or you've got any kind of subsidy, Section 8 voucher, project-based, low-income housing tax credit, any government subsidy for a unit, that unit's going to be subject to CARES. It's going to be a covered dwelling, and then you're going to have to issue a 30-day notice. So in Arizona, we call it a 530, 5 days to pay, 30 days to move out. But Arizona's a cure jurisdiction, so in reality, it's 30 days to pay or move out. I got confirmation in Nevada yesterday. The court's going to require a 30-day notice there too, until the end of the year at least. Because the problem is the CARES Act is not very clear on its sunset date. I'm going to argue it's going to be dead at the end of the year. But there's not really a clear date, and it's an act that I think was put together hastily, and it's got its problems, and we're working to correct that. But right now, there's no appetite on Capitol Hill to come to any kind of consensus, and so the gridlock is causing some problems, which is, it's going to lead to some delayed cases. So our clients, I'm telling them that they need to issue 530s if they're a covered property until the end of the year. Now, the court in Arizona has come out and said if you're seeking a balance, it doesn't relate to the period of time the CARES was in place, and that's March 27th through July 25th, that you can issue a regular 5-day notice. I don't agree with that. I think that was not correct because I don't see anywhere in the CARES Act that supports that. It's ambiguous. I'll certainly give them that, but I think it's a bad idea to be a little bit too loose with the rule. And I think maybe the conservative approach is the better approach.
So let me understand this correctly. You have to give so if someone doesn't pay rent and they're on a covered property, they have a Fannie Mae, a Freddie Mac, or one of these type of loans, they're going to give what your company calls a 530. That means 5 days to pay the rent or 30 days to move out. Is that how I understand it?
Correct. And it's the same notice. It's one notice.
Yeah, I see. Okay, so that's just for CARES Act. That's just for covered properties. If you have a property that's free and clear, then you can just give a regular 5-day or a regular 7-day. Of course, you can't give anything right now. We will be able to, I guess, on September 1 now in Nevada. Start their evictions on, unless there's some other wrinkle in the matter, which I hope there's not. Because I do feel for a lot of these people. I manage for people. Jose, I know he manages for people, and we have people that haven't paid since March. And it just seems unrealistic. Especially when you see everybody's out and about. This is what gets you upset. The people are out at the restaurants, they're out at the bars, they're at the casinos, they're driving around. There's traffic jams, there's lines at McDonald's. Come on, man. And so, now we're having, and it just seems like, why can't you move out of your house? How many evictions are there? How many evictions a month do you think Arizona has? Do you have that number offhand in Nevada? Well, how many go through the system per month, roughly?
Are you talking about Nevada or Arizona?
Both of them, or either way.
In Nevada, the stats are not given to me so readily in Nevada. Our firm processes about 500 cases at its high point in Nevada a month. In Arizona, we have a different situation. I've got not to say I don't have a good relationship with the court in Nevada, but it's a little bit more of a open dialogue between administration and the Arizona Multi-Housing Association in this office. And so I was on the call with the Supreme Court last week, and the number was, I think, 1,500 or 1,600 evictions in June or July, both June and July.
Is that for Arizona?
That was Maricopa County.
Maricopa County. So they had about 1,500. Which month again?
In both June and July.
Okay, but on a normal month, like pre-COVID, how many evictions do they usually have?
About 6,000.
6,000 a month. So this could be. There could be a lot of people laying out there that haven't paid rent on that.
There is. The Arizona Multi-Housing Association has been really good about providing information both for our leaders and for our members. And that information has basically revealed that about 1.6 to 1.8% of all renters in the state of Arizona have done what we call ghosting their landlord. They don't talk. They don't communicate in any way. They don't pay a penny. And there's 982,000 units in the state of Arizona. And so that's a significant significant number of units affected by this. When you start thinking about the average rent in Arizona being about $1,000, I think about 867. I'm sorry. So Elliott Pollock did a study and basically came up with what the economic harm has been associated with this. If 1% of all Arizonans don't pay their rent, you're looking at a loss of about $67 million for property owners. Yeah. If that percentage went to 15%, then it's $1.3 billion in lost money. And if you go to 30%, you're talking about $2.6 billion in lost revenue.
Yeah.
Property management companies and owners. So
I was just astonished. I read the white paper from the lawsuit that you guys put out from the AMA, which I'm a member of as well. And I could. The numbers are staggering. $1.3 billion is going to be. I just see the courts being just completely tuned up when this starts. Nevada for sure, because Nevada hasn't had an eviction, and no evictions have happened there. And they have to be on the same trajectory, I would think. Not as big because the population's smaller, but it's got to be percentage-wise as great or greater than Arizona when you look at the transientness of both places,
I think it has to agree with you on most of those points. I point this out to the court. And I was on a call with them a little bit before I got on this. And you have to remember this. You're giving someone 30 days to move out from a carriage property. It's a lot of time to give someone to move. And so we have a lot of cases that, we have far more notices issued than we have cases filed. It's about 4 to 5 times the number of notices issued than cases filed. Whoa. So if you're talking about now, we're taking the cure period and we're multiplying it by 6. How many more people do we have moving out in that time period that we're not going to end up filing an eviction on? Because I can't file an eviction on someone if they turn the keys. They have to be in possession of the property when I file and serve them. And if they're not, then it's not an eviction. It's a small claims case or a civil lawsuit, depending on the dollar amount. And the same thing goes for Nevada. Nevada is a very transient state. People move from these apartments just on a whim. You would be amazed how quickly people just move. And so you give them 30 days to move out of a home. They're going to do that. And there was an interesting article. I can't remember what publication it was, but I think it said 80 to 90% of tenants paid their rent in August. And this is what I've been hounding with our counterparts, the NEA, and anyone that'll listen to me. You have to have access to the court for the landlord to compel the tenant to pay. And so
Right.
I have a strong belief that some tenants went, the gig's up. I no longer have protection under CARES. I need to pay, which is great. I want people to pay their rent. I want them to get rental assistance. The state had $139 million in rental assistance. It was very slow in Arizona, very slow in letting it out. Nevada has a pittance as far as rental assistance. Arizona just released a foreclosure prevention fund at $5 million for property management companies and owners, which, unfortunately doesn't really even get at the issue. And they only earmarked half of a $2.5 million for large property owners and $2.5 million for small. And if you're looking at, 1.8% of renters are ghosting their landlords, the drop in the bucket. It's not going to fix it.
So, yeah, absolutely.
This whole thing has been, a somewhat government caused problem. I mean, we shut down, and I'm not a health professional. I'm not going to say that was a good or bad decision. It's in the past. We deal with it. But the ramifications are that my clients' constitutional rights were trampled on. The freedom of their contract was just obliterated, and they were forced to provide government housing and for no charge. And that's an injury that's going to be long lasting. That's going to be an injury that's going to cause a lot of problems in Arizona for landlords. And the solution is put funds out there for landlords to obtain, or streamline the process for tenants to. And what I have to say in response to 2020-49 from Governor Ducey is thank you for at least changing the protocol. I don't appreciate the extension, but at least he put in place the tenant has to complete a rental assistance application in order to avoid the writ of restitution, because at the end of the day, at least my client gets paid. Yeah. And I'm happy about that. I have not been happy for 4 months telling people, I understand, but I'm sorry. I can't do anything. I can't evict your tenant. I can't stop the hemorrhage of your loss. And as a property attorney, someone that values property ownership and understands how far a dollar goes that's rent paid, and I don't think anyone understands how little of that dollar the property owner gets to keep. This has been very difficult.
Yeah, I was telling Jose earlier that I says, it's no different than, us going into either Safeway or Vons here in Las Vegas and just loading up our grocery cart with a bunch of groceries and pulling up to the front and tapping the manager on the thing and saying, I'll pay you in 90 days. I mean, and walking out the door with the groceries. And, and I just think these governors have they're either clueless of what's going on. I mean, they're just absolutely clueless that the tenant, if they can't pay 1 month, how are they going to pay, 6 months or 7 months at the end? But yet the landlord has got to pay the property taxes. They got to pay the insurance. They got to pay the maintenance people. And by the way, in Nevada, and I know in Arizona as well, make sure you keep the place fixed for them every time they call you for something broken. I mean, I just, I look at that and I say, and I've been saying the constitutional rights from day one. I started I called Scott way back when it first started. He put me to Colin. I talked to Colin, and I was furious about it. I'm like, somebody needs to go and step up and file a claim with the Supreme Court. This is unconstitutional, and it's going across the whole land, and we're all doing it. Now, I don't know about the 1918 pandemic, if they suspended people's constitutional right, but I don't think they did. I don't have that information. But one of the things that is that the founders of our Constitution, they all too well knew about pandemics, epidemics, all those types of things. Their whole society was made of those things for many, many, many years. They knew all about that. But yet there's nothing in the Constitution that mentions that anyone's constitutional rights get suspended over a pandemic like this. Hey, look, I'm not advocating that it's not real, because it is. A lot of people have died. I got it. There's some fuzzy math that I'm very unhappy with. Number counting. It seems like there's been some political things with that as well. But hey, I just don't think you can suspend it. Now, if the government wanted to protect the people, then they should have had in place money to pay the rent for people. Nobody else in this pandemic, nobody, Walmart, Amazon, you name the company, if they've provided a service, they got paid. Nobody has been able to walk out the door without getting paid. That's been my position, and yet they've turned this thing into, they hijacked everyone's property and they put it for government use, and the landlord hasn't been paid. And oh, by the way, pay the mortgage. It seems to me like it's been just ridiculous, what's been going on. But now, to turn to that, there's going to be a Supreme Court hearing, or there has been, or I don't know. Are you involved with that, Chris? Are you one of the attorneys, or did they hire different attorneys, the AMA? What? And there's some things going on there. Can you explain to us a little bit about that?
Well, I can't get too far ahead of it. I can say that I'm not the counsel in that case, but I'd have to direct inquiries. We're still in the infancy stage of this, and we did file. We filed Wednesday evening. I don't know that a hearing's been set yet. I think that it might be set sometime before the end of the month. There's going to be a briefing schedule. Governor Ducey did get asked a question about it yesterday in his press conference, and he had a rather interesting response. He told us to get in line. I wasn't sure what line he was talking about, whether it was the rental assistance line or the line of people suing him. But our lawsuit was lodged on Wednesday, and then also on the same day, the water park sued him too. And he's also got that lawsuit with the gyms and bars. So we've got 4 industries that have sued Governor Ducey over his orders. And so I can say this much. I do think the Supreme Court's going to weigh in here. I hope that they would. You have 4 major industries in the state of Arizona that are saying, hold on, this seems pretty much unconstitutional. We've suffered losses and we can't do it in perpetuity. Please, someone help. And so I hope the Supreme Court will hear the case, and I'm optimistic on what's going to happen. I'm not going to say Governor Ducey is without his rights to protect the state of Arizona and its citizens. I certainly agree that he has that right and that obligation. And I think oftentimes when we have a serious situation, we have a tendency to react first and think later. And I think now we've got the benefit of hindsight and look back and say, okay, well, maybe was there a different way of approaching this? And reasonable minds can differ on this, but I certainly think that the Supreme Court is going to take on the case. I look forward to their analysis. And I will say for the CARES Act, and I'm watching that case too, there is a case in Texas where property owners did sue the federal government over the CARES Act, and I'm looking forward to that too. As a little bit of a nerd when it comes to the constitutional issues, I'm looking forward, the next 4 or 5 years to learning the plethora of constitutional law that comes out of this crisis. And hopefully, at the end of the day, it'll provide guidance for what to do in the future. And I think that's the way we got to look at it. We got to trudge through what we're in right now and hope at the end of the day, there's some guidance that prevents some things like this from happening, or at least limits it so that it's not as painful as it's been.
Yeah, no, I totally agree with you. He does have a right, I believe, to protect the public. I'm all into that, but I don't think he has the right to protect the public on one party or another party, private party's back. That's where I'm at with it.
Protection under the law.
Yeah,
that's the fundamental concept in the Constitution.
And I've talked to people differently. And I've talked to some other, attorneys too. My brother-in-law is one, and they're basically there's there's interference of contract here. There's due process involved. They keep running around, and I just want to take whatever I can help them with it. Like they keep running around saying the tenant has to pay. Yes, they do, but are they going to pay? And what's going to hold them to pay? Is the government going to go after these people? And are they going to take their taxes and their refunds and give them to the landlords that they owe money to? Maybe that should have been a consideration. Or, another consideration that I thought in the beginning was they're going to give them $600 a week plus whatever the state of Nevada and Arizona is going to give them. And I thought, okay, why don't they cut that down and say, who's your landlord, and pay them directly? And then they wouldn't have had to worry about any of these eviction problems. Everyone's money, everyone would have been paying. We've been fortunate as a firm. We've only had 2 people. And one called us and they're just throwing us whatever money they can give us. That's in Nevada. In Arizona, we've had nobody. That's a pretty good thing. The thing with us is, we try to do really good screening, and I commended all my staff. We've worked straight through this. Our office has worked straight through this. We've worked in an office together. The whole period. We have never stopped working. I've worked every day through it. The only thing we did during the pandemic is that we lowered down. We didn't allow anybody to come inside the office, but we had already been working on that for months before through online payments, online work orders, and that type of stuff. So we were already there. We just finalized it where there's nobody in the office, and then we stayed an A team and a B team. We had an A team that stayed in the office because we did not know how severe this was going to be in the end. So we quarantined. Myself, my daughter, and somebody else, we quarantined them away from the situation. That's Jose, by the way. We quarantined him, and then we had our regular office stayed there working. If anyone would have had contracted it, then I would have had the B team kick out the A team, and we would have come in and run it. So we've stayed, pretty good with it, as far as we've been doing. I think that's about everything that I had in question. Jose, do you have any questions that you wanted to direct towards Chris with Las Vegas? Or
he pretty much answered the question, which is what I had, so I'm good.
Yeah, okay. So hopefully in Nevada, September 1 is going to come. It can't come fast enough for me and Jose as well. So we have some people that we have to deal with, very swiftly, and we are, but the thing is it's going to be so backed up, I think, in the end that it's just going to take forever to get through, or they'll start slow walking them if they don't want to do them too fast. So I just wanted to thank both of you, Chris, for your time. I know you're very busy, especially at this time, and I appreciate you coming on to us. I've known you for quite some time. I've been doing business with your boss for like 20, 25 years. So we've had a great relationship there at the law offices with Scott and everyone else there. And we really appreciate all the hard work you guys have been doing. And we respect it. We know what's been really going on. So because we're part of it. So without any further ado, I'd like to thank you, Chris. I would like to have you come back to our show again sometime. If there gets another, if we have some more rumblings here, I know we may have something coming up with the Supreme Court here coming down the road. I really do think that the Supreme Court thing is a really, really big deal. If his order does get overthrown, I believe that could reverberate to many other states and many other jurisdictions, and might be pointing out to that, depending on the legal argument. It's all about the argument, how it's going to be presented. But again, thank you both very, very much. And I look forward to, speaking with you guys again in the near future. Okay.
Yeah, thanks for having me. I appreciate it.
Thank you very much. Take care, you guys. Have a nice day. Okay.